In July 2011, the Brillante Virtuoso was boarded by armed gunmen who allegedly planted an IED, causing an explosion and fire. Salvage services were rendered to the vessel, following which the fire reignited. The claim was pursued by the mortgagee bank and its subrogated MII insurers, as the owner's claim had previously been struck out by the court for failure to comply with the disclosure order.
The bank said that the armed gunmen that came aboard were pirates and had been allowed to board by the master, who thought that they were an expected security personnel for a transit through the Gulf of Aden. War underwriters said that they were there under the instruction of the owner and boarding to place the IED. The bank said that the fire then reignited due to a damaged stopcock on a diesel fuel oil tank, but dropped that allegation as the expert evidence evolved during the trial. War underwriters said that the salvors had deliberately restarted the fire on their arrival to the vessel.
Having considered the sequence of events as alleged to have taken place by the bank, Mr. Justice Tier said that there was no plausible explanation of the events consistent with an innocent explanation. He found that the loss of the vessel was caused by the willful misconduct of the owner.
The court then had to consider whether, notwithstanding the finding that the owners had acted with willful misconduct, whether the bank could show the operation of an insured peril under the ITC war risk clauses. Despite a novel argument that the owner was acting as a pirate for the purposes of the bank's claim, the bank could not show that the facts supported the operation of any insured perils. The bank had also argued that the insurance policy gave rise to two contracts of insurance, one for the owner and one for the mortgagee bank, in the hope that this would allow the bank to avoid being tainted by the owner's willful misconduct. Having identified that the bank could not show the operation of an insured peril, Tier J did not consider it necessary to make a finding to this end, leaving over this important question for another dispute.
This is the second scuttling judgment arising from deliberate fires in 3 years. The judgment shows how the court would approach the assessment of complex evidence, competing factual accounts, and when the burden for showing a deliberate act is met.